Okay, we'll give it 30 more seconds and then get started. Okay, let's go ahead and get started. Good morning, everyone, or good afternoon if you're on the East Coast. I'm super excited to welcome you to the second SABA Health Law Section webinar of the year. We have three wonderful speakers with us today, and Shireen Gomez, who's going to be speaking and moderating, as well as Payal Shah and Judge Vaitiswaran, will be talking about mediation, arbitration, or litigation, choosing the right path for your dispute, specifically in healthcare law. Before we get started, a couple of quick housekeeping things and introductions. My name is Astafar. I am one of the co-chairs of the Health Law Section, along with Amy Kabaria, who's also on the line. We are really excited to revive the Health Law Section, so if you have ideas for webinars, please feel free to reach out to us. And while the webinar is going on, I will also put the link to the WhatsApp chat in the Zoom chat so that you can join the Health Law Section's WhatsApp chat. And before I turn it over to Shireen, quick housekeeping things as well. We have two polls which will come up. Shireen will announce them when they're coming up. So if you can take those and participate, that would be great. Outside of that, we're not expecting you to talk much or anything. Just attend, listen, pay attention, and thank you so much for joining us. Shireen, it's all yours. Let me know when to start sharing the slides.
Okay, thank you, Asta. We can get started. Um, so we're going to be talking today about how to select the best path to resolve a healthcare dispute. And with us to discuss and give their insights are Judge Anu Vataswaran and Payal Shah. Judge Vataswaran's litigation experience includes jury and bench trials, as well as administrative advocacy. She previously served as a judge on the Iowa Court of Appeals and is currently an independent arbitrator and mediator, as well as a panelist with the American Arbitration Association, handling international and domestic matters that involve all types of disputes, including healthcare. I asked each panelist to share a fun fact with me, and Judge Vataswaran said that she has two cats who likes to put her laptop in airplane mode. So hopefully they are occupied with other technology matters today and won't interfere. And we also have today Payal Shah. She's senior counsel with Vituity, a multi-specialty healthcare and physician partnership that has offices around the nation. Payal's been practicing healthcare law for over 12 years with a focus on payer-provider disputes, outpatient medicine, regulatory guidance, and business strategy. Prior to joining Vituity, she was in-house counsel at Blue Cross Blue Shield and has also worked for a large nursing home. Pyle's fun fact is that she hates cilantro. Although I like cilantro, I'm sure you're not alone in that. And my name, as Austin mentioned, is Shireen. I'm a director with the American Arbitration Association, administering healthcare matters. So let's get started with the quick question to get the audience thinking. I think we can all relate with the dispute that may have taken longer or cost a little more than expected. So if a dispute hit your desk tomorrow, where would it belong? Um, we have several options, of course, and so we're going to be covering some of those. How do you decide what option is best suited to resolve that particular dispute? And what path, how do we choose the right path? So with that, I'm going to just briefly go ahead and turn it over to Pyle and Anu so they can say hello before we get started.
Hello, my name is Anu Vaitheswaran, and I want to thank Shireen and the American Arbitration Association, as well as SABA and Astafar, for inviting me to be a part of this. It's a pleasure to be here and chat about healthcare law.
Thank you.
Hi, everyone. Thanks so much. I'm really honored to be part of this panel and to work with Shireen and Anu and talk about healthcare disputes and where they fall. Thank you again to SABA and Asta for putting this together, and really looking forward to this conversation.
Okay. So each of the primary paths, mediation, arbitration, litigation, have different goals in mind, and they also have their own risks as well. So understanding the trade-offs, the pros and cons are critical. With that, let's start with what some of the options are and discuss kind of what goes along with it. So first, mediation. Judge Vataswaran, I know you do mediation and arbitration cases. Can you explain a little bit about how you can convince a skeptical client to use mediation? What are some of the benefits, and maybe what is a misunderstanding that people might have about mediation?
Sure. Mediation is an option that allows people to sort of direct the course of the outcome. They are actively involved in figuring out options that would help to resolve the dispute. And the mediator is largely a facilitator exploring those various options. In addition, the mediator may be an evaluator and provide some guidance as to which type of option would be more feasible. And that is sort of the overarching role of the mediator. What happens in mediation is that these folks will try to get a resolution. It can be particularly successful if both parties are invested in resolving the matter outside the courtroom, and where there might be some emotions at play that wouldn't play well in a courtroom.
Okay, thank you for that. And I'll just briefly mention about arbitration. I think it is a party-driven process. It can be binding or non-binding. It's typically a binding process. And typically it's a contract obligation, though parties can agree to arbitrate their dispute, even if it's not in their contract. Some of the considerations are the time that it reaches resolution. It's oftentimes quicker than court. And then you have a decision maker that might be an expert in the field versus a judge that might have to be kind of have to have briefs on some of the particular topics, so they won't have any familiarity with the issue ahead of time. So let's go with the litigation. Payal, your thoughts about what is a big misunderstanding about litigation, and what are some of the pros and the cons that you can think of for litigation?
Yeah, I think, oftentimes people want to jump to litigation, for optics or to show that that would be something that could set a precedent, which in many cases it can, but it's very costly. It can take years. And there's the whole appeals process. And so sometimes it can take, over 15 years to get a decision. Whereas if you had gone through mediation or arbitration, you can sometimes get a decision quicker and it can be less costly. But it really is a strategic business decision based on, case law, what's effective for that particular matter. It can, also depend on jurisdiction, right? And where if that case was in a certain state or jurisdiction where case law is favorable for that particular matter, it might make sense to go through litigation. It is a formal process and there's public records. And so that can certainly help with PR and optics for certain cases. And I think, there are instances where you want a jury trial, right? And you want or a certain judge that might be favorable to the type of issues you're discussing. And so in those instances, it's good to weigh the pros and cons to see if litigation makes most sense. And if it does, then it would be a better route to go than arbitration or mediation.
Okay, great. Now I'm going to start getting our audience involved a bit. Can we put up the first poll? So
It's
the
already on, yeah.
Okay, sorry. I think the question or the issue is that I think the slide has to be advanced. Sorry. So what we have is the question. It's a hospital system versus a medical device manufacturer. The issue is a defective implant and a contract fallout that results after that. So the scenario is a regional hospital system entered into a multi-year supply agreement with a medical device manufacturer for orthopedic implants. After a spike in post-surgical complications, the hospital stops using the devices and withholds payment. The manufacturer denies defect claims and alleges breach of contract. So with the poll, let's see how many people think mediation is the correct way to go, how many think arbitration, or how many think this is ripe for a litigation. If you can just provide your answer. And we'll see what everyone thinks. Let me know when the results of the poll.
I can't apparently multitask, but the results are 50% mediation, 50% arbitration, and 0 litigation.
Wow, I find that interesting. No one selected litigation and they opted for mediation and arbitration. Judge Wataswaran, do you have any comments with regard to this scenario, what you think might be best?
Yes, I think mediation could certainly be a preliminary step to see if there are ways to negotiate a resolution, a monetary resolution on the breach of contract claim. I wonder, though, whether, given the breadth of this claim and the nature of the parties, that arbitration might be the more viable option. At that juncture, both sides can present their claims to a neutral arbitrator who is presumably specialized in healthcare law and can get a resolution after the hearing within about 30 days. And so it's a quick and efficient process. Discovery is limited, but that in fact allows for the speed and efficiency of the proceeding.
Great. And Pyle, do you have any thoughts?
Yeah, I would just add that, arbitration also would make sense in this instance. Again, there's no one right answer, but arbitration may make sense because of the optics, right? You're looking at patient safety issues here. You're looking at a hospital system that wants to serve its patients efficiently and effectively. And so arbitration might be the best way to um, close out this issue with lower costs and with more speed than a litigation.
Great. Yeah. And some other advantages with arbitration or mediation. Mediation is not binding unless the parties agree to a settlement agreement after the fact. And then with arbitration, it is confidential. Sometimes that might be important to one or both of the parties. So with that, I think we'll keep going with some different hypotheticals that we can just go over. So the next one has to deal with hospital network, and a managed care organization. And I'll just let you briefly give a couple minutes so you can read that and then we can discuss it. All right, hopefully everyone had a chance to briefly skim that one. So we'll go with Pyle first this time. What do you think about this dispute that's arisen, and what do you think would be the best option for the clients? for the parties?
Yeah, I think this is one where, could again go either way, but I think arbitration or even litigation could help with this matter, especially when you're talking about patient access and continuity of care issues. You want to send precedents, especially to the managed care organization, to state that this is not okay, and you don't want to see that issue rising, at a larger scale. And because of the optics of it, it could be beneficial to show that this is limiting patient care, and so litigation could help with that. At the same time, because it's an issue where you want to quickly get access to patients and resolve this issue for both parties, arbitration could work as well.
Right. Okay, thank you. And then Judge Vataswaran, your comments on this scenario?
I agree with everything that Kyle said. I would simply add that there might be an arbitration clause that would mandate arbitration before litigation, and the parties might want to consider that. In addition, if there are interim measures that either of the parties want, they can obtain those kinds of measures or that type of relief even within the arbitration setting. The rules do provide for emergency protection and some type of protective order.
That's a great. All right. And then can we go to the next hypothetical?
Shireen, do we also want to discuss some background on contracts before we jump into additional scenarios?
Sure, sure. Go ahead. Why don't you start with that?
Sure. So I think, often to backtrack a bit before you get to this stage, right? You're looking at the contract itself if a contract is in place, and you're looking at the resolution clause and whether you're in the initial stages of drafting it with the other party or you're on the receiving end evaluating it. There's, a few things to look at that I think can be beneficial. It can help before this process even starts. So you want to kind of look through the dispute resolution clause and see, do you want to make it more broad or do you want to tailor it more? And when you do that, do you want to apply it to only certain types of cases and matters, or do you want it to apply to every single matter that comes across? And that's where you can really tailor a clause that would fit best for your organization or, for your client. Locale really matters, right? If often the company, for example, is headquartered in California, you might want the jurisdiction to be California law because it would be favorable maybe to your organization. And there are other things that you can also consider where if you think that there are certain claims that would be beneficial to go through mediation first and then arbitration, you could state that where, mediation would be required prior to going into arbitration, or arbitration would be required before you would, and litigation would not be something that you would want to consider, and that all matters should go through the arbitration process, and you could choose an agency like AAA to address that. And so these are things that you can really consider based on your client and will be beneficial for them when you're crafting the dispute resolution clause.
Yeah, I think that's a great point, and it can't be stressed enough that it's so important to have a good contract to rely on before a dispute even arises. So it's very important at the negotiation stage to draft a good clause that thinks of things like you mentioned locale. Do we want one arbitrator or panel? Sometimes clauses are too rigid. They try to make it so narrow. So think about the broad or the depth of the scope of the clause as well. Some get really specific with regard to discovery and whether there's an appeal option, things like that. So it's important to look at all those and decide. You don't want to be so specific that it ends up kind of cornering your client when you need it if a dispute does arise. So that's a great point. Judge Vataswaran, do you have any comments on drafting a good arbitration clause or drafting a good contract with options in it?
The only thing I would add is that the American Arbitration Association does provide assistance with drafting arbitration clauses, and that is a really nice feature to examine before clauses are drafted to ensure that all the provisions that both Shireen and Pyle have discussed are in the provision.
Yeah, there's a great tool and it's a free tool that anyone can access called Clause Builder. And it kind of walks you through the steps of what kind of provisions you want to have in your contract. There's also an AI version, so if you like that, and it seems to be everywhere these days, we have both the AI version and the regular version, so you should check that out. So let's get back to our scenarios, and hypothetical number 2 deals with a pharmaceutical manufacturer and a distribution partner, and there's a supply chain disruption issue. So I'll give a few minutes just to kind of skim that scenario, and then we can discuss it a little further. So with regard to this dispute, Judge Wataswaran, do you have a option that you think this dispute belongs in and why?
So I think this is particularly suited for arbitration. I think this type of contract claim could be resolved fairly expeditiously in the arbitration setting with fairly minimal cost. There are opportunities to have experts even in the arbitration setting. And so if the parties feel that they need experts on any of the issues relating to supply chain or that sort of thing, they can certainly obtain those experts. And there is also a provision that allows the parties to agree to a forum. So that would assist both of them in moving forward with the arbitration.
Okay, thank you. And Pyle, your thoughts on this one?
Yeah, I agree. I agree with Anu. I think, especially with the patient impact here, I think arbitration makes most sense. And I think because this could impact different jurisdictions, across different state borders, perhaps even, it makes sense to have an arbitration to efficiently deal with this matter.
Okay. Now the next one, it's going to be probably one that you both deal a lot with. Healthcare insurance provider versus a healthcare provider. And this one's a little bit longer, but we're going to talk about it a little bit more in depth. So I'll give a few minutes to everyone to kind of skim through this. So this one does involve a multi-step dispute resolution clause, and it continues on the next slide, please. All right. So this one does involve quite a bit of money, and it seems like tensions are high on both sides with executives, the physicians, and the clients. And so let's discuss this one. Pyle, how about this? How would you approach this or go about evaluating what's the right option for this dispute?
Yeah, well, there's a contractual clause here that would need to be followed, but presumably, if this were to jump to litigation, this would be, I think, a good case for litigation, considering the high amount here, as you mentioned, 12 million, and the fact that you're looking at various issues that could be really explored more deeply through a longer discovery process. All these documentation processes, coding procedures. You could look at, billing and different data sets. And this is where, expert testimony and different, economic experts would even be of assistance to look at the data and to really evaluate the payments and, what was industry standard. And so I think in general, this is a good case that we often see in litigation and probably would do well in litigation because of the issues at stake here.
Okay, thank you. And Judge Ratnaswaran?
Uh, I agree. This type of case could certainly be in a court forum. I will also mention, though, that it seems to be the type of bread and butter case in the healthcare arena that is being litigated in arbitration. And so, even though there are some complex issues, the attorneys seem to be uh, concerned about the expeditious resolution and are working on minimizing discovery to allow for that, while at the same time calling experts and trying to get those complex issues before the arbitrator in a seamless way. So I think it certainly could be in the court system, but it could also be an arbitrable issue or an arbitrable case.
Okay. Do you think
Yeah.
mediation? Oh, I'm sorry, go ahead.
Oh, no, I was just going to add that I think to Anu's point, I think this is also one where, you know, because of the relationship here and something that both parties might want to continue for the future, this could be a good case for arbitration where you could then work out a future agreement for going forward rate that would be beneficial to the patients in this instance because it would, then help both parties and the physicians wouldn't be as frustrated if they had maybe had a better reimbursement rate going forward. And that's something you could negotiate through the arbitration process too.
Okay, so it seems like both litigation or arbitration might fit in this one. How about mediation? Do you think mediation might be a good option or to do handle this dispute?
I think the parties could certainly start with mediation because they do have an established relationship. And it is certainly possible that they may be able to get some, if not all, the issues resolved through mediation and then limit the scope of arbitration to the outstanding questions that remain unresolved.
Okay, yes, that's great. So when do you think mediation works best versus arbitration versus litigation? Pyle, your thoughts on that one?
Yeah, I mean, not considering contractual obligations, I think in general, I think mediation works well when, there are fewer issues that you feel like you can work out and where you either have still a decent working relationship or you feel like that's something you want to continue on with that opposing party. Especially with like, health insurance companies, for example, providers certainly want to continue that in-network relationship. So it might be beneficial to just go through mediation to resolve certain payment matters, get that settled, to continue to be in contract or in network going forward. And so sometimes mediation does help resolve those issues. If, again, the amount might be lower, there's just limited number of issues, especially for, related to coding or reimbursement. And there's enough through the discovery process where you wouldn't need something, that would expand a more deeper, expansive process. But I think there are other times too where I would I think Judge Anu mentioned this. I think arbitration sometimes is now often more favorable just because of the efficiency of the process, and it's still binding versus going through litigation. It just makes more sense. No one wants to spend that much money and time going through some of these claims anymore when they could just be resolved through arbitration. The one thing that we didn't talk about earlier is that now with the fact that a lot of the arbitrations can be done virtually, that also limits the client's costs in terms of travel, in terms of, attending hearings. And that can also play a huge factor, especially if you're dealing with a case that's across the country or in a different location. And so I think that's where mediation arbitration also is favorable.
Mhm. Yeah, I think that's a great point. I think coming out of COVID, we all realized that we can do some things virtually, and sometimes a lot of people prefer or like to have that option to do a remote hearing or a remote mediation. Have you seen a lot of that in practice, Judge Vaideswaran?
I have. Uh, Obviously, before COVID, teleconferencing and virtual proceedings were almost unheard of. They were definitely the exception rather than the rule. But since COVID, that seems to be the preferred option in a very large number of cases, primarily because of the cost, and also because it facilitates proceedings where people are spread out both across the country and across the globe. And I've seen both situations where parties just feel that a virtual proceeding is going to work better under those circumstances.
Yes, it's definitely convenient. So it's nice that we have that option, especially for international or multi-state parties. So, Judge Vaideswaran, you did mention kind of a hybrid um, approach where we might have a mediation arbitration or arbitration mediation. And this could be either clause driven or it can just be by the agreement of the parties. There's also early neutral evaluation, escalation clauses. Um, so have you seen that in practice, doing kind of a combination of two of these or more in trying to get at a good resolution? Pyle, how about you in your practice? Have you seen a lot of that? Or would you encourage it in your future cases?
Yeah. Judge Anya, do you want to answer first? Um,
So I've seen sequential use of mediation and arbitration. I have not been involved in the simultaneous use or contemporaneous use of both, which may raise some conflict issues that are not present when you have a mediation with one person and then a subsequent arbitration of issues that may not have been resolved in mediation. So that's my experience.
Right, thank you. Did you have any other comments?
no, I mean, I largely agree. I also think I just wanted to add that with mediation too, you know, because it's not binding, that sometimes can give more flexibility to both parties to work something out because it's kind of a lower stakes game of your trying to work it out. But and sometimes there could be time left, right, with the mediator where you don't resolve it that day, but if there's time left, you can still come back together to resolve it. Versus arbitration, then at that point you're just prepared, just like a mini trial essentially, right, to move forward and to resolve the issue. And so again, it just depends to what sort of outcome you're seeking, but that's where, either mediation or arbitration can be more favorable depending on the matter and depending what you want out of that case going forward too.
Right. Okay. I think next, we would be remiss if we don't mention AI or the technology and innovative things that are coming out in the legal field. And in practice, I'm curious if things are really trending that way. So the use of technology in virtual proceedings is there. Are we seeing things like AI use of court reporting for transcript or using AI in the research and drafting stages? I'm curious about that and what you think about it. If is it a good idea or not? And then where do you think dispute resolution, how do you think that might look 5 years from now, or what clients will be wanting 5 years from now? Who wants to take that first?
So I guess I'm happy to speak to the question of use of AI in drafting, in brief drafting. And the only cautionary note, and there are a number of cases now that have been decided on this question, is that ultimately it's the attorney's obligation to review any product that is generated by generative AI to ensure that the case law is accurate and to ensure that every piece of it, application of law to fact, is accurate. And so, to the extent that the parties are using generative AI to draft documents that are then submitted in arbitration, it's incumbent upon them to double check the work product.
Of course, very important. We have seen some case law or cases regarding that. Any other comments, Pyle?
I would just add from more of a business perspective, that the use of the AI technology can really assist with some of the background document gathering or analysis, or even assistance with some of the expert information that might be needed for a case. And that's where AI can really cut down on certain costs, but provide, more materials and documentation quickly so that it's less of a burden on the client or corporation to spend internal resources doing that type of work.
Okay. Yeah, it will be interesting to see how it advances as we go towards the future. It's definitely here to stay, I believe. So let's do, I think we're coming to the question and answer section. So before that, can we do the last poll? I'm just curious what percentage of our audience practices. Are you in litigation? Are you in alternative dispute resolution? I would just like to see who is out there today. And then let me know when the poll is done.
Yeah, so far looks to be 50-50.
Oh, okay. It's interesting. All right. So I guess we can do any questions and answer at this point. Do we have any questions in the chat for any of us?
No questions so far, but if anyone has questions, please feel free to use the Q&A button. Oh, I see it. Question: how to best handle recoupments in terms of settlements?
Okay, who wants to take that?
I think that issue is the same whether one is in litigation or arbitration. There is a question as to how you will, whether you're going to enforce the judgment by confirming the judgment in the district court and then proceeding with processes that may be allowed in state court. And that, my experience is more in the litigation context as opposed to the arbitration context with respect to that. But certainly there can be issues in both.
Okay.
Yeah, I would largely agree with Anu. I think it could just go either way.
Okay, one more is how long does arbitration process take versus litigation process? I think that this is probably a good point to discuss in this. And maybe actually, why don't we add mediation as well so we can discuss all three from all three of your perspectives?
Okay. I guess I can take it first. I know that we've had statistics that show that it is faster than going to court, sometimes almost a year faster. So it does seem to be a little bit more efficient way if parties are wanting to, if that's an important thing for them. Anyone else?
Yeah, I found that for both mediation and arbitration, I can generally get a case heard or resolved within a year or maybe 2 years max, versus some of or most of the litigation cases get drawn out much longer because there's also, considering court dates and then different hearings, continuances, appeals process if that's relevant. And so it just can take a lot longer. And I found that with mediation, even more particularly, you can get that a date in less than a year and start moving forward with those conversations.
Mhm.
I agree with that, especially in the healthcare arena with the large dollar numbers and the complexity of the issues. The cases in arbitration seem to get hearing dates within a year or 18 months, whereas that same case in a litigation arena would take substantially longer, obviously, depending on what state you're in. But I think it would be fair to say that very few of those types of cases are going to get resolved in that time frame in any state.
Yeah. Yeah, I know. I think the courts were backlogged, especially coming out of COVID. Um, so, are
And
there, I'm
and I think
sorry.
we really quickly, when you touch upon the fact that now they can be virtual, I think that helps too, because that can often move up the court dates for
Mhm.
immediate arbitration versus having to go in person and make sure all parties are available on that day to be there in person with travel and everything else.
Good point. So I think kind of as a conclusion, there's no single best way to resolve the dispute. I think you just have to look, everything's kind of custom made to the situation, and then also what your clients want, the goals of their what they would like to happen. So just to kind of evaluate it and see what might be the best option. And I would just like to get a takeaway thought from our panelists. Judge
We have,
Lettisberg, do you have, I'm sorry,
there's one more
one
question.
more question.
Yeah,
Okay.
and then we can do
Sorry.
takeaways right after. How likely is an insurer to proceed to litigation after settlements fall through? Sometimes it feels like a money grab and all talk with no follow-up.
I think, generally insurance companies are not afraid to go through litigation. I think, um, in my experience, that's what I found. I feel like they don't mind the delay in the process. They feel like, um, especially if they're bigger insurance players, they feel like they have more weight to go through a litigation process versus being bound by a settlement through an arbitration that sometimes isn't often as favorable to them. But that, it could go both ways where the other party, a provider party, for example, might find it more beneficial to go through litigation as well because they want to set a precedent. The optics look better, right, for the provider in that instance versus an insurer. And they might want to get a decision from a jury that would be more long-standing for that group, especially in terms of a future contract, future rates, or what that would look like for patient care. And so, while I think in the media we see that insurance companies are really aggressive and really wanting to always litigate all matters, it does, I think, also depend on the issue. And I think more and more we're seeing other groups now, like provider groups or other associations, even, right, like medical associations, pushing for litigation over arbitration to also show that they have an important cause that really they want the media light and PR to showcase their causes and claims too.
Any other questions?
I think that's it. So if you want, sorry, Shireen, go ahead with your
Oh, yeah.
last question.
No, I was just going to say any key takeaways from today, any thoughts on particularly either mediation, arbitration, or litigation, or anything that you'd like to leave our audience with as a closing note.
So, from my perspective as a former judge, I think in whatever forum an attorney is practicing, their most important asset is their reputation. And if they can preserve that reputation, they'll be in great shape.
Mm, yeah, that's a great point. And Pyle,
Yeah, that's a great point because I think everyone wants a fair judge, and so that will follow, or an attorney that's really reasonable, and I'll follow them throughout their career. I just wanted to add that in terms of deciding which of these three to pursue, again, outside of contractual obligations, just be strategic. Think about all the different factors we talked about, or that might be reasonable for you to consider for your client or your organization, and think creatively too, right? Which can provide more long-term solution for your client, and try that route out. There's no right answer, but the good thing is that sometimes by pursuing one and then, for example, like pursuing mediation and then arbitration, you have more options and you can kind of see the playing field and get an idea too of your opposing party.
yeah, that's great. Yeah, so if you take away anything, I think it's that, don't just be one-sided. There are other options, and you could use a combination of things to see, because the ultimate goal is to get a good resolution for your client, and something that the both parties will, be kind of happy with. Um, and thanks, Asta, for letting us discuss this today, and thanks for having us on.
Yeah, thank you so much for your time, Shireen and Payal and Judge Vetheeswaran. Really appreciate it. And I learned a lot of new things. I primarily practice in managed care, so it was interesting to hear about scenarios from the other side of healthcare. So thank you for doing that. And again, if any of you want to get in touch with the panelists or with Amy and I, we co-chair the health law section for South Asian Bar Association. Feel free to use this LinkedIn post that I just put in the chat where you can find their profiles. And if you want to join the WhatsApp chat, I also included a link to that. And thanks again, everyone, for your time, and especially to our speakers for the really well thought out presentation today.
Thank you.
Thank
Yeah.
you.
Thanks, everyone. Take care.
Bye.
Bye.